number 60, the people of the state of New York versus Don Williams. Counsel?
Thank you, Your Honor. Can I reserve 2 minutes for rebuttal?
You may.
Thank you. Good afternoon. May it please the court. Helen Syme on behalf of Mr. Williams. The drafters of 31030 may not have imagined the use of a projector to display copies of statutory text inside a jury deliberation room. However, their imaginations provide no limit to ignore the statute's demands. As Justice Gorsuch said in Bossick versus Georgia, when the terms of a statute give us one answer and extra textual considerations supply another, it's no contest and the written word is law.
Counsel, do you think display and give are the same thing?
I do, in this context. If the digital projection here was not giving the jurors a copy of the text, it would allow judges to project the text on the walls of the deliberation rooms without violating the statute. And that's exactly the evil the legislature was trying to prevent here when they enacted this provision.
Well, wait a minute, I think I'm not following. If display and give are the same, which I think is what you said, then the first clause says that in the presence of the defendant, the court must give the requested information, which you read to be display. So I don't know how that could be inside the jury deliberation room.
I'm sorry, could you repeat the question?
Sure. I'm not paying attention to the last sentence for a second of the statute, right?
Sure.
Of CPL 31030. I'm looking at the sentence right before. You said give and display are the same. With me so far?
Yes.
Okay, so I could substitute where it says must give the requested information to must display the requested information, and you would say that's equivalent. And that sentence says, in the presence of the defendant must display the requested information. So I don't understand when you say this display could be done inside the jury deliberation room, how that could be done unless you were going to bring the defendant into the jury deliberation room, which I've never heard of.
Your Honor, with respect to the first section of the statute, there it's an umbrella term which would encompass the second provision. And because the second provision is there as kind of an added restriction, whether the defendant is in the deliberation room or not, I think this would still violate the commands of 31030 simply because consent wasn't provided.
Well, counsel, I'll refer you to People v. Baker, which is our 2010 case where the judge used slides instead of an overhead projector. And there the court held that using the slides were not the same as giving the legal definitions to the jury because they didn't go back with them to their deliberation.
Your Honor, I would submit that that case is different because it was a prosecutor who displayed the instructions in that case during the argument phase, and the judge instructed the jurors that what's said during closing argument is not the law. The judges specifically said you must take the law from the court as it's read to you. So I believe that that's different.
Counsel, over here. I think Judge Wilson making the point that give means different things in different contexts. So it's difficult to just read that statute and say, okay, give here means this, give. But if we look at kind of the harm that the statute and our due process cases is looking to address, it seems to me you kind of can break that down into the judge gives written instructions, sends them back that are self-selected, emphasizing one thing more than the other, and related concerns to that. Or the jury gets this material in the jury room without any supervision by the court and starts to muck around with the statutes. None of that mischief, as you could call it, is present here because there's no objection by counsel that other instructions should be projected, and there's no risk that they have this material in the jury room where they can use it unsupervised by the court.
This should not be a harmless error case. It is reversible error because the mandates of the statute
But I'm
have
not
been
talking
exceeded.
about error. I'm just saying if we're going to read the statute with the intent of the legislature, it seems that the legislature was looking to address that potential harm, which we've identified in our cases, and this give doesn't raise those same concerns.
I think this give does raise the same concerns, especially because in this case, it's a partial distribution, just the elements.
But no objection was made to that, right?
No objection was made to the partial distribution, but that's why the statute requires consent, so that the parties have a say in what should be projected or shouldn't be based on the request of the jurors.
Correct, so it wasn't a partial distribution. In essence, they were answering the question that the jury had asked. It wasn't a question of emphasizing or overemphasizing anything other than what the jury requested.
In this case, I do think the secondary format placed additional emphasis on those instructions. However, even where the entire charge is distributed to the jury in People v. Johnson, this court found that it violated the statute and was inappropriate. The fact that it's...
Because they had it back there and could use it back there. And I think that's kind of the trouble we're having. They can't do that here. They may remember it better, but they are not looking at a written distribution, as we've said in Owens, I think. They're not looking at that and using the writing without the supervision of the court. And so I think there might be an argument if there had been an objection and certain parts were displayed over that objection, you could say maybe due process or some argument you have about the selection was aggravated by the projection, but it doesn't seem that it's a violation of give.
The fact that it occurred in the courtroom with the judge supervising would essentially create a nullity for the consent requirement. If the court could do this regardless
But
of...
they can do it. Like if the judge gets a request, he can read the statute without consent. You don't need consent to read back, if the judge had just read these statutes, he would need consent. So isn't this just the equivalent of that? So the point is you don't need consent.
Counselor, I'm sorry, go ahead and answer the judge's question. I didn't mean to interrupt.
I think consent is still necessary in this case, because if the legislature intended to carve out a exception for that here, they would have done so. And the fact that they required consent specifically for anything involving statutory text is demonstrative that that's the issue they're trying to address
Well,
here.
couldn't that consent be that exception be in the statutory text? 310 does say that the court can provide information as it deems proper. And it sort of speaks to this idea that if it happens in the courtroom and the judge is there to oversee its use within the courtroom, as long as that it's deemed proper, consent isn't really a requirement. It's when you get into the jury room where the judge cannot oversee what's going on that suddenly consent seems to make more sense.
The fact that the first provision allows the judge discretion in responding to jury requests does not authorize a specific override of the third provision of 31030, and that's this court's holding in People v. Johnson. And the fact that the legislature specifically omitted any type of exception for the conduct done.
The judge couldn't take the statute or part of his charge and hand out written copies to the juror and say, follow along with me, jurors. You can read this, right?
That's correct.
But he could do that if there was consent, correct?
That's correct.
So isn't your argument really that in requiring an objection here, I'm assuming as part of a preservation argument, you're negating the consent requirement? The consent requirement gives the defense an advantage. There's no question about that. And the legislature seemed to define it that way, to give that advantage to them when you step outside of the statutory protocol that's set out in the CPL.
That's correct. And allowing such overrides, should this occur in the courtroom or under the supervision of a judge, essentially overrides that additional protection that the legislature
Well,
intended.
in some ways, you could argue that it even does more than that, because by doing it that way, you're doing what the Owen Court, particularly in the Boone Court, particularly said you shouldn't do. You're selected portions and implying greater importance to them. But I think here that was partially negated by the fact that the jury is asking about this. So, of course, you've got to respond to that. That's perfectly reasonable. That doesn't really apply. I think it really comes down to whether or not the written instructions and whether they're written on a piece of paper or written on a visual thing that we read off the wall Whether or not that reinforces oral instructions, as the visualizer would do, that's why it's put there, so that it violates the precepts that are set out in Owens. It seems to come down to that for us. Would you agree to that?
Yes, and
So
I think,
forgetting about what the result is, it seems to come down to turn on that question.
I believe so as well.
Thank you, counsel.
Thank you.
Counsel?
Morning, Your Honors. Kaylin Porter on behalf of the people. Where the court does not give the jury a copy of statutory text for their use during deliberations, consent is not required.
So let's go to Judge Fahey's example. Could the judge hand out printed copies of the instructions in open court and then collect them before the jury went in?
Yes, Your Honor, that would still fall under the first provision, and we would be then analyzing whether that was an appropriate exercise of the court's discretion. It's because it happened in the courtroom that's really the definitive factor here. And I know Judge Fahey referenced Boone and the Owens cases.
Yeah.
In that case, they listed out 3 specific dangers, and all of those dangers applied to the jury taking a copy of the statutory text back with them. None of those dangers apply here. The first 2 is the selection and the repetition of certain portions of the court's charge. That danger isn't present because the jury...
I just discussed that with her. I agree with you about that, except on the third point. I don't agree with you about the third point. The third point is whether written instructions, and these are written instructions, the question is how they're inputted, but they're certainly written instructions, reinforce oral instructions. And it seems that the legislature made a determination that written instructions do reinforce oral instructions. That's why I'm trying to hone in on that part of it.
I understand, Judge Fahey. So the language in Boone and Owens, that third danger was that those instructions would be reinforced by their physical presence in the deliberation room. That obviously wasn't the case here. The written text was never physically present in the jury deliberation room. That's uncontested. The fact that it would be...
I hate to get semantical with you, but God help us, I suppose we have to, right? You're right, it didn't go into the jury room. The question is whether or not, as Judge Wilson just said, you could hand them out, and it would be the same thing. And I guess I'm having a hard time distinguishing, but you're saying that that's okay. Is that right?
There's nothing in the statute to prohibit that. So the 31030...
And you don't think that the case law specifically prohibits that?
No, Judge Fahey. All of the cases in which this court found there to be a violation of the second provision of 31030, in every single one of those cases, physical text went back to the deliberation room.
So if we had a visualizer here and you had prepared your oral argument and we put it up there, I'm pretty sure we would all be paying a fair amount of attention to the visualizer and less attention to you. Is that a problem as regards a jury? Don't we want them focused on the judge, watching the judge, listening to the judge, and not trying to do things at the same time?
I would say that that would still be a reasonable accommodation that the court would be allowed to exercise its discretion in doing. The only mandate of that first provision of 31030 is really that the court gives a meaningful response to a jury request. Here the jury...
Look, counsel, let me ask you a different question. Could the judge have given that written copy up front of all of the instructions at the beginning, right? And then when they come back, only have given the portion they requested? That's one example. Versus not give any written instructions up front and then only give the written instruction that's requested. Do you see those as perhaps different in any shape or form?
Be distinguished from our case, Your Honor, because that court would be acting sua sponte. And though that was part of the danger that was identified by this court in Owens, here that's not the case. The court wasn't acting on its own. The court was responding to a jury request. And under the...
So then if the jury had not requested the display and the judge did the display, you would say then that's reversible error?
No, that would still fall under the court's discretion under the first provision because it happened in the courtroom. The real distinction between the two provisions of...
I'm sorry, so then why can't a judge give, or perhaps I misunderstood you, why can't the judge at the beginning give all of the instructions in writing and say, read along with me, I'm going to read them out, and then before they go into to deliberate, take back the written documents? Or did I misunderstand you?
No, there would be nothing in the CPL to prohibit that, Your Honor. Really, the distinguishing factor is whether that text went back to the deliberation room.
So could the judge just hand out the written instructions and say, when you finish, raise your hand and then I'll collect them? and not say anything orally. Not read the instructions out orally at all.
Under this court's consistent ruling, what it turns on is whether that went back to the deliberation room. If it's all happening in the courtroom under the court's supervision and guidance, it would be viewed as to whether or not it's in.
I'm sorry, maybe, does Owens say that?
Owens lists out the 3 specific dangers. The first,
Well, no, I know that it does that, but in Owens, now, you can correct me if I'm wrong, because you probably know it better, but I thought written instructions on part of the criminal charges that the defendant was accused of were given to the jurors, and that, and I think they listed out the elements of the crime. But, of course, the court did not give out instructions on the defendant's agency defense, only gave them on that. And this court said, you can't do that.
the language of Owens relies on the physical presence in the jury room. It doesn't turn on whether it's
Well,
written
Wait a
or.
minute. The facts of the case don't support the argument that you're making. It's written instructions given to the jury when he's instructing them on a particular element of crime. I forget what the crime was. That's contrary to what you're arguing to me.
Perhaps I'll be a little bit more clear. So 31030 splits it into 2 separate provisions. The first provision, request for further instruction or information. There's a very specific procedure as to how that's to be done in the courtroom. That's exactly what happened here because the entire procedure took place within the courtroom. It doesn't turn on in what manner the court gives that instruction. It's really just as the court deems proper, and the court has significant discretion in determining the scope and the nature of the response. Here, this was an appropriate exercise of discretion under that first provision, and the court complied with the jury's request in that regard. The second provision does have a consent requirement because it involves sending statutory text back into the deliberation room. Where no statutory text went back into the deliberation room, consent is not required. And this court has strictly construed that last consent requirement in all of the cases before it.
Counsel, could we look at it this way? I agree with you. Owen speaks to physical presence in the jury room of the written instructions, right? Distribution, but the final risk is written instructions physically present in the jury room. That's their language, I believe. That's the statutory argument to me. So whether or not those things go back and you need consent, that's one issue. It seems to me there could be an argument made going to some of the hypothetical questions that have been asked where the judge sua sponte hands out certain portions of the charge and has them read them, raise your hand. You could start to get towards a due process issue there, not a statutory violation, but I believe your argument here would be that's not this case.
That's not this case, because we would be looking at it under the first provision as to whether the court gave a meaningful response.
And what's your view on whether or not the due process argument's preserved here?
It's not preserved, Your Honor. The objection in this case was very specific to the use of the visualizer. Now, under the first provision of 31030, the court has to give meaningful notice. That's a mode of proceedings error, but whether or not the court gave a meaningful response is subject to a harmless error analysis. So that's what we have here, and so this would fall under a harmless error analysis. Preservation would be required. It would only be if this court did find that the second provision applied and that consent was required, would this be per se reversible. But as I've stated, this is about whether the court gave a meaningful response to an express jury request happening within the courtroom.
Yeah, I think there is validity to your statutory argument and the limits on it. I think that's a reasonable argument. Judge Kay said something interesting, and it was in a case, People versus Martell. She talked about how Owen should be applied. The site on that is 91 New York 2nd, 782. Anyway, she said, relatedly, we have also held in Owens that it's impermissible for a court on its own initiative to distribute written experts of its charge to the jury over defendant's objection, concluding that this practice presents the same danger of misuse as when 31030 is violated. In other words, the danger is the same, even though it doesn't fit that statutory construction. And so if you limit yourself to 31030, I think you have a stronger argument. It's when you look to the effects of the case beyond it that your argument becomes more problematical. That's my view of it anyway.
Your Honor, I mean, I did cite the Martell case. I do find that the Martell case is pretty instructive. Some of the language from Martell is that there's no meaningful distinction between endless readbacks and what happened in this case. And I do think that's well illustrates the court's exercise of discretion under that first provision, that as appellant has suggested, that the court merely reread and reread the same portions over and over rather than comply with the jury request. There's really no meaningful distinction between what happened here and the court doing that. That's a reasonable accommodation.
Thank you, counsel.
Thank you, Your Honor.
Thank you. Counsel, your rebuttal?
Thank you. This case does not turn on whether the information is provided inside the jury room. In People v. Townsend, the court removed the instructions before the jurors were deliberating and before they could take them back into the deliberation room, and the case was still reversed. And should the legislature have intended such an exception here, they would have written it in the statute, and we're required to assume that they would have written it down. Allowing such an exception would override the consent requirement and make it a nullity, because should the court decide that the instructions should just be given to the jurors inside, consent's not required in the first place, and it's clear the legislature intended that the parties have some say on what written material the jurors are given in this case. So I would ask this court to adopt the rule that says, absent consent, 31030 prohibits judges from distributing written instructions in any format.
Thank you,
Thank
counsel.
you.